can't see my lawyer. I have to see my lawyer. I want to see my lawyer. Simple. Can I see him? What's up?
He is no longer be held for any reasons in their gulag. Thank you. I can't see my lawyer. What's up, nonsense? I have to see my lawyer. I want to see my lawyer. Simple. Go away. Let me see him. Can I see him in this environment? What's up, nonsense? Have we seen something that is private? I'm telling you. Stop. No.
Of justice.
Did they come out of the way now? Take it. Please let him wait now. Let's get him taking the baby.
Oh God. That when we're still at the preliminary stage, the first accused person, that's Mr. NNAMDI, raised an objection to the fact that he does not have confidence in the judge that is sitting today, and that he wouldn't want the court to try the matter because he has information pointing to the fact that he will not be given fair trial in the court. And the court, though this irrespective of the fact that the prosecution opposed that application, we amplified his grounds because we're there to do his bidding within the ambits of the law. We amplified it and then made the court to understand that once an issue of fair trial is touched on, it goes to the root of the trial because it has to do with fundamental rights. And then whatever provisions that you have in the Administration of Criminal Justice Act 2015 that is in contrary to Section 1 sub 3 of the Constitution is null and void to that extent. And then the court saw reasons with us once more to say no, that since he has raised an issue that borders on human rights and fair trial, that he has no reason to continue to try a man who has no confidence in his court. Because justice is a three-way traffic. The justice to the court, to the prosecution, and then to the accused. And on that basis, the court ruled in favor of the first accused applicant on behalf of other accused persons, and then disqualified himself and made an order that the file should be transferred to the CJ for reassignment.
Now going forward, would you still proceed, because there's an earlier ruling by Justice Demola admitting your client to bail. Would you pursue that?
Yes, like I said, that order is still subsisting, especially when there is no charge against my client. There is no reason why my client shouldn't have been released to me here, because the court of competent jurisdiction has made an order. And this is the same court, this is the same Federal High Court that they've come today to charge my client. In other words, you reprobate and approbate. You will want the court to do certain biddings for you, and then you will not obey the court when the court says, do for me. So that order is still subsisting, and we are letting the world know that my client is still being held by the authority, contrary to the order of court of the 16th of December, 16th of December 2015.
Is it based on that order that your client is refusing trial?
No, it has nothing to do with the trial. The trial is a different thing altogether. Thank you. We continue to press for the release of my client. That is the only thing we know. We'll continue to press for the release of my client. So if at the end of the day, it is left for the administration to decide on the court where they'll take the charge. Whenever they invite us, we'll be there. But what we're saying is that he is no longer being held for any reasons in their gulag. Thank you.
There is something that when it happens, you can't afford to remain silent. You can't afford to remain silent when certain things occur. Like this morning, I woke up and read the charges, the new charges Nigerian government filed against NNAMDI KANU after a whole week of disobeying the latest court order for him to be released. I was shocked. It is so funny. It is so funny the way Nigerian government has taken this whole Biafran KANU thing. The truth is this. Many Igbo elites did not believe that what KANU was asking for was feasible. We did not believe that Igala, Idoma, Bayelsa people, some people in even Edo State, the Delta people, will come and join the 5 Igbo states and form a Biafra. Now, nobody believed that. We did not believe that the Igbos will withdraw from Abuja, particularly the Igbo elite who built all the hotels and those things in Lagos and Abuja, will withdraw and go back to the east and form a Biafra. Now, in fact, Biafra is no longer about geopolitics. It's no longer about physical territory. Biafra is just an ideal of human right. It's an ideal of equality of treatment. It is the right of all members in a federation or in a wider political unity to demand for equality. That's what Biafra is. Biafra is not about maps. Biafra is not about territory. Biafra is about human right and equality. It's an ideal that is beneficial to all people. That ideal of equality and fairness is beneficial to the Shiites. It's beneficial to the Kogi people. It's beneficial to the Zango Kataf people. It is beneficial to people in Benue State. It is beneficial to all people in the world. That's what Biafra is about. That's the only thing Biafra can be about. Biafra is not going to be about territory. I don't want to close my office in Lagos and put it up in Enugu. No, it doesn't make sense. But then why is it that the government of Nigeria can't get this idea? Why are they clamoring and doing all this nonsense about NNAMDI? Look at the funniest of charges they filed. It's very important for you to read these charges so you see how dumb it is. And doctor, look at it. You will laugh. The charge against NNAMDI reads that you, NNAMDI KANU, and the other unknown persons now at large in London, United Kingdom, between 2014 and September 2015. Can you see how dumb it is? Look at the timeline. The timeline of the offense is stated as between 2014 and September 2015. That's incredible. No prosecution, no prosecuting authority will define a criminal timeline in such a vague manner. Because the timeline you define is going to be determined by evidence. You're going to use the evidence to track the timeline. So, if you don't have any evidence of a particular date in 2014 when NNAMDI made a move, then you won't be able to prove that offense. And if you have that evidence, then you have a date that evidence came into existence. That will be the date you specify. So to even not mention a date in a month in 2014, so that means between January 2014 and December 2014, KANU did something. That is dumb. A more proper articulation of a criminal charge will mention dates with particularity. And that date would be based upon what evidence is available to establish a conduct. There must be a conduct. There must be an act in 2014 that you frown at. If you know that act, there must be a date when that act occurred. So now they come up with this vague timeline. They said, with intention to levy war against Nigeria in order to force the president to change his measure of being the president of the federation. That is so dumb. This president was not in office in 2014. So what is the idea? Okay, I thought they said that KANU was what Jonathan put in place, or Jonathan are using KANU's quest to undermine Buhari. But the charge says that indeed KANU wanted to force Jonathan to change his measure of being president. And by the way, what is this idea of to change his measure of being the president? Is being president a measure? Is it a policy? This is incredible. There's no doubt that the charge against NNAMDI KANU is a bogus charge calculated to justify the disobedience of court order or to continue the disobedience of court order. That's nasty. Now, if you look at the rest of the charges, you even laugh more because it says things like, oh, they had a radio broadcast in London. Somebody in London had a radio broadcast, and you said that the intention of the broadcast was to wage war and cause the president to change the measure of being the president. That is silly. In our democratic system, any political actor, any opposition politician wants to cause the president to change the measure of being the president. Since 2002, President Buhari had been trying to cause the various presidents to change their measures of being president, because he said he wants to be the president. Each time Buhari wanted to be the president, he was trying to cause whoever was the president at the time to change his measure of being a president. Nonsense. What matters is what KANU did. And apparently by this charge, what he did was to make a broadcast. How does making a broadcast become such an offensive thing? It falls within the constitutional permitted free speech. It is his free speech. Anybody in this country can make a broadcast and abuse the president. They can call the president anything. They can call him an idiot. It is their right. And that's why the Constitution allows the president to hire people like Femi Adesina and those people to come out and say the president is a messiah. That is democracy. Some people will say the president is a messiah. Some people will say he's an idiot. It's all allowed. You don't start framing all these stupid charges because somebody wants to cause the president to... Indeed,